Good afternoon, ladies and gentlemen. Welcome back to Bexar County Court at Law number 6 and the Bexar County Veterans Treatment Court. I'm Judge Wayne Christian. Today is Friday, the 30th of December, 2022. It is approximately 10 minutes after 2 p.m. in the afternoon. The cases I have set for hearing today are cause 664105 versus Christian Navarro, Representative Mr. Albert Acevedo, and cause number 657-729, State of Texas versus Daniel David Trevino, represented by Ms. Suzanne Kramer. And representing the state is going to be Mr. Jonathan Alvarado, representing the Bexar County CSCD, Ms. Susan Gross, who I will swear at this time. Ms. Gross, please raise your right hand. Do you swear the testimony you're about to give to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Okay. With regard to Mr. Navarro, the first document I have in his case is entitled Defendant's Consent for Motion, to motion to revoke hearing by video conference. It apparently has both Mr. Navarro's and Mr. Acevedo's signature on it. In fact, Mr. Navarro, is this your signature on this document, sir?
Yes, Your Honor.
Thank you. And Mr. Acevedo, as attorney for Mr. Navarro, is this also your signature on this document?
It is, Your Honor.
Thank you. The next document I have for Mr. Navarro is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions revoking the community supervision, but not the underlying conviction. Is this your signature on this document also, Mr. Navarro?
Yes, Your Honor.
And Mr. Acevedo, as attorney for Mr. Navarro, is this also your signature on this document?
It is, Your Honor.
Thank you. This is a motion to revoke community supervision. My understanding, Mr. Acevedo, is that this is going to be an uncontested motion to revoke community supervision. Is that correct?
I never stated it was uncontested, but I can't plead true to some of the violations. We could plead true with an explanation for a few of them.
Understand. Why don't you tell me which ones you would like to plead true with an explanation to?
So we'll go with 13, 15, 16, 17.
(13, 15, 16, and 17), and it appears that 13 talks about failed to complete 80 hours of community service, I guess, restitution, and 15 talks about failed to register for or attend the CATSNP program. 16 talks about failed to register for or attend certified DWI education program. And 17 talks about failed to register or attend the DWI victim impact panel. And these are all being pled true with an explanation. Would that be correct, Mr. Acevedo?
Yes, Judge. At the time of filing, they weren't complete, and we have an update with the court today.
Understand. Fair enough. Ms. Gross, would you please advise the court and the parties of the status of Mr. Navarro's probation, including today's update provided by Mr. Acevedo prior to this hearing?
Yes, Your Honor. Mr. Navarro has been reporting as directed. We last saw him on November 21st, 2022. He has paid $102 towards his fees. He has a balance of $1,315. He's currently delinquent $711. We have no record of any of his 48 hours of community service having been completed. Today, we received an update that he completed his DWI education on December 25th, but we have no proof of a certificate. He completed the victim impact panel on December 22nd, and he did provide a certificate for that. And he also provided proof of enrollment 2 days ago into the CATSNP program. To date, he has had 4 negative drug tests, and he has failed to submit to drug testing on 6 occasions. He is on a portable alcohol monitor at this time, where he is testing 4 times per day. And to date, as alleged in the motion, he had 56 skip tests. And since the motion was filed, he's had an additional 12 skip tests and no high bracs. The officer is recommending that his probation be extended an additional year, that he do weekly drug testing, and he be ordered into a cognitive behavior class.
Okay, and Mr. Acevedo, what are you requesting?
Judge, I'm requesting Mr. Novato to be continued on this probation. It currently ends July 15th, 2023. I'm in receipt of the court summary, which states when he's been told to UA, and I guess the allegation is that he didn't submit the UA the day he was told. He recently received this new probation officer at the end of October, and when he received this officer, it's been nothing but problems. I myself spoke with the place that does the actual urinalysis test for my client, and they advised me that the probation officer wants him to do a $20 test, but they don't have the update in their system so that they can't order that test. So that's been one issue. In terms of this other stuff like proof of employment, residence, that was provided to the previous probation officer. The new officers giving him a hard time about it. Nothing's ever changed. But I also did provide the same proof of employment and residence of my client. There are no positive UAs because he's not using drugs or alcohol. He hasn't skipped his test with the machine. At one point, there was a malfunction with his device. He turned that in. And since he's had this new device, which is the Lifesaver device, he's complied with the conditions. He showed me in front of me, he's taken a test, and then it says a next window for Sunday. Well, we're Friday, not Sunday. So I told him he needed to get a hold of Lifesaver. If there's any issues with the device, he needs to talk to Lifesaver. But as far as him actually skipping tests, I think that's inaccurate. But this probation officer has made it a little more difficult for my client. When he met the probation officer on October 18th, she said, "Can you provide a UA?" I believe the following day. Well, my client took the day off from work that 18th to go report to probation, and then asked her, "Can I take this right now? I can't take off the next day." So I believe he did end up taking a UA the following day, but I don't think it was to the probation officer's liking because it wasn't at that same time. He understands how strict this is. He understands he's not supposed to be drinking. He understands he's not supposed to be using drugs. He's compliant with this probation, Your Honor. He's not going to give this court any problems. I don't think it's necessary at this point to extend him, Judge. I'm just asking the court to continue him. He's missed work since December 20th. He's been on full house arrest, and he's managed to get these things done, which he understands the court ordered back in May of 2022. And now he's on the ball with the classes, and he's scheduled to report for the CAT snip this Tuesday, Judge.
Let me back. I'm sorry, go ahead, Susan.
I just have a couple of comments in regards to the verification of employment. They're supposed to provide that every month. So why this is being made a big deal of, I'm not quite sure of. So we did get a photographic copy of a screenshot of his employer's information with his manager's name and telephone number, etc. But he's supposed to provide check stubs on a monthly basis to verify his employment. As far as the drug test goes, he oftentimes shows up too late at the lab to do the testing. I've talked to his officer at length. When an officer tells them that they have to go for a drug test, there's a reason why they're told to go that day or within 24 hours, not when they feel like it or when it's convenient for them. So for him to not go when he's told, yes, it is a violation.
All right, let me back up. So my understanding is that the probation department has a record of Mr. Navarro failing to submit to urinalysis drug testing on June 15th, 2022, July 12th, 2022, August 10th, 2022, and October 18th, 2022, and November 22nd, 2022. Is that correct, Ms. Gross?
Yes, and actually there's one new additional one. He also failed to go on December 17th, but the motion was not updated.
Okay, and I believe Mr. Acevedo indicated that he may have been late for some of these, or did he just totally miss all of these? Do you have any knowledge as to maybe he got there the day after some of these, or an hour later, or whatever, or the lab was closed? What, on each of these individual tests, I assume there are different reasons why he wasn't there other than he just didn't want to go. Do you know any answer to that question?
Judge, I am looking at his UA schedule, and as far as what is actually logged in, and I'm going to actually log into NORCAM where he is sent. I'm going to do that right now. But it appears that he just flat out skips. Hang on. Okay, according to his testing, I'm having to go between two screens here, so please be patient with me. June 15th, he was supposed to go. We have no record of him showing up. July 12th, he was supposed to go. We have no record of him showing up. August 10th, he was supposed to go. We have no record of him showing up. He did go on his own on August 12th, and that one was negative. So it was 2 days after the date. Then after August 12th, he was supposed to go in, let me see, it looks like he went October 18th, he failed to go. He did go on October 19th. That one was negative. He was told to go on November 22nd. He failed to go. He showed up on November 23rd. He was supposed to go December 17th, and he failed to show up.
I mean, can you tell me on October or on those dates they were negative though, according to the summary, right? You're saying he was went
The
the
ones that he
23rd.
actually did submit to, yes, he was negative, as I stated.
You didn't say negative, well, you said that he went. So what about the November 21st sent to lab test? Is that something completely different?
No, that means that he was told to go to the lab and he failed to go.
All I
And
see is sent
and
to
he
lab.
finally went on November 23rd, and that test was negative.
Obviously, we're pleading not true to those allegations, Judge. I mean, this is hearsay. She's not the individual that ordered these tests. We would need the actual probation officer to come in here and testify as to that information. But as to him submitting, he's submitting his UAs, Judge, and he's also on the device where he's blowing into that device. That also tests for alcohol. That's the point of the DWI monitoring. So we can sit here about semantics regarding the whole taking the UA that day, he took it the next day. He's also on this portable breath machine, which he is blowing in, Your Honor.
All right, let me back up. Let me get all the cards on the table with regard to the UAs. Is it 5 or 6 UAs he didn't show up for initially?
6.
6, okay. And out of those 6, he subsequently, the day after, showed up for 2 of those 6. That's correct, and tested negative the day after?
I'm not sure on day afters, but he has a total of 4 negatives, and he has 6 failed to submits.
Okay. If he failed to submit, we can't get a positive or negative. So
Correct.
he shows up the next day, we get a negative the next day. But that doesn't tell us anything about the day he was supposed to go, correct?
Each time he failed to submit, except for once, he showed up 2 days later, which if you are a chemistry major or you have street knowledge, you know that there are things out there available that you can clean out your system with.
Oh my goodness.
All right, I'm not worried about that. All right, I got that figured out. Now let's talk about skips. And this is a Smart Start mobile device or a LifeSaver device, or what kind of device are we talking about?
He is on LifeSaver.
And he's blowing it 4 blows a day, supposedly.
He is supposed to be testing 4 times per day. That's what he is scheduled for. And the term of the motion includes 56 skip tests. And then since the motion was filed, he's had 12 additional, but no high bracs.
Hard to get a high brack when they don't blow in the machine.
How many pass tests does he have?
I don't have that number.
So
I'm sorry, what was
we're-
that question, Mr. Acevedo? What was the
How many
question? I'm sorry.
pass tests do you have? We're magnifying the number of skip tests, but we don't know the time he skipped them. We don't know the follow-up. I don't have any of this information in front of me, Judge. I know we're worried about him skipping blows, but my client has this machine and he's in compliance with it. I can't sit here and have a full-blown hearing regarding those issues when I don't have proof from probation regarding them.
Okay, I don't even understand your question. Let me back up. He's blowing 4 times a day, or like he's supposed to be blowing 4 times a day. And
Correct,
obviously, sometimes in the past, he hasn't blown 4 times a day.
correct.
So on a month, and over what period of time are these 56 alleged skip tests? Let's ask that question.
Give me just
1 month, 2 months, 3 months, what are we looking at?
The skip tests started on 13 July and go through 11 November. And then he's had an additional 12 skip tests since the motion was filed on December 15th.
So
That's
is that
not alleged on the MTR.
everybody stop talking, please. So that's an approximate 4-month period of time for 56 skip tests.
Yes,
So it's like five skips a month, something like that. Does that sound right?
no, he had 56.
56 skips, 4 months.
So that would be more like 12 to 13,
Oh,
13.
yeah, I got 11 point something. All right. Do you agree with that, Mr. Acevedo? Approximately 11 skips a month.
I mean, based on what they're alleging, Judge, I don't have the documents in front of me to say I can agree with that's what he's skipping.
All right.
'Cause
I got you.
according to my client, he is compliant with it, so I don't have the records for those documents, Judge.
Judge-
Okay. Anything further, Mr. Acevedo? You have any other issues that we need to chat about?
No, I mean, Judge, also, he's gainfully employed. We provided that information. That's
Yeah, I'm
part
not,
of the
I'm not
issue,
worried
I
about
guess.
that aspect
Well-
of it. I'm more
well, I
worried
think that-
about the reporting
Judge-
for UAs and for blowing in the machine.
In terms of the past test, you know, if we're gonna go off based on their testimony of the summary, it also says 59 past tests for that starting July to August, 69 from August to September, 51 from September to
Are
October.
you talking about, hang on a
58
second. Are you talking about the breath
Pass.
testing machine? Or are you talking about UAs? Breath testing
The
machine?
breath testing machine, Judge.
He's obtaining that information off the violation report, which you should have, Judge.
Well, with 56 skip tests, he probably has plus or minus 4 times that of not skip tests. Do we all agree?
Yes.
Or 3 times that not skip tests?
Judge, to make it easy
More
and
than
put
that,
it on
like
the
5
record,
times.
Yeah.
from July 13th to August 12th, the officer reports that there were 59 past tests, 11 skips. August 12th to September 11th, 69 passed, 10 skips. September 11th to October 11th, 51 pass, 13 skips. October 11th to November 10th, 58 pass tests, 22 skip tests.
Okay. What was the original fine on this case, if you know, Ms. Groves?
The original fine was, hang on, give me 2 seconds. $500.
Okay, I got it. Anything further from the defense? I'm going to ask for the state recommendation.
Judge, just gonna reiterate, obviously I know we're reading off what the allegations in terms of missed blows and compliant blows and UAs. I don't have the document in front of me. I can't verify that stuff, but I can verify the fact that my client is in compliance currently with probation.
It appears to the court that after you became involved in this case, he started doing things. Does that make sense? He started knocking out programs he should have done earlier. So he's done several things now he hadn't done before. Does that make sense?
I would agree with that, Your Honor. I also think that sometimes there's certain officers involved that may not be more accommodating than others. And, I think once he got this new officer, there was a shift in how he was being treated. And now this officer, when she files the MTR, alleges these violations when she wasn't even his supervision officer. So maybe one officer was being a little lax and the other one is being a little more strict. He understands the nature of these charges and he understands probation. And he understands he needs to be in compliance with everything, Judge. From my point of view, Judge, I just don't think it's necessary to extend him an additional year for this charge when he does have the device and he is in compliance. I think there may be a malfunction with the device. That's why I can't plead true to those violations.
And Susan, this is a straight DWI first. Is that correct?
Yes, Your Honor.
I got you. State recommendation, please.
Yes, Judge. I would more or less concur with probation's recommendation. I don't know, and Ms. Gross may be able to give me more information or give the court more information if the extension is necessary because of the recommendation for the additional class. But he's supposed to terminate in July. 7 months would seem long enough to complete the classes. But the other thing, Judge, I would add is that given the concern about skip blows, not reporting for UAs, we could up the blows. We could also make it a weekly UA or bi-weekly as opposed to a monthly. That would be my suggestion, Judge. But I don't think revocation, since it is a straight probation, is really necessary at this point.
Okay. Mr. Navarro, in cause 664-105, the court accepts your plea of true with an explanation to conditions 13, 15, 16, and 17 on the motion to revoke community supervision. I grant the state's motion to revoke your community supervision. I sentence you to 90 days in the Bexar County Jail. It says a $500 fine plus court costs, credit for time served, time and money to run concurrent. You're to report to the Bexar County Jail at 9:00 a.m. on Monday, January 2nd, 2023. Altering and amending conditions, recalling all pretrial services, bond conditions, and warrants at the time the defendant surrenders to the Bexar County Jail. I could have given you an additional 90 days, but Mr. Acevedo started to clean up your act and got you to do some things at the last minute, which I'm giving you credit for. Anything further from the state of the defense on Mr. Navarro? Last I heard, they were getting 2 or 3 for 1 in the jail. I don't know what it's going to be. The sheriff decides that, as you're well aware, Mr. Acevedo. You might know more about that.
Just from my point, Judge, so we're not following the recommendation of a year. Instead, we're going through 90 days Bexar County Jail instead.
That is correct.
Judge, I mean, he's going to lose his job because he has to go serve his time. Is there a way we can do work release, or if it's something that we can serve on the weekends?
Feel free to talk to the jail. Back in the day, I think back when you first came on board as an attorney, we had work release, meaning the person slept in the jail and then worked during the day at his job. Because of COVID, my understanding is they don't have work release anymore. Now they have a home. You have to stay at home on GPS or something and work during the day system, but I'm not doing that. So,
Judge,
if you go back to the other system, let me know. But obviously, I've got a whole nother 24 hours on this job before I go on to other things.
Now that the system has changed, I mean, would you consider allowing the extension for a year so that he doesn't have to go turn himself in and lose his job and everything?
No. Feel free to talk with the new judge, and you get a second shot at her, obviously.
Thank you, Judge. And you said, just so I'm clear, in terms of turning himself in, it's January 2nd.
Am I correct? Monday is January 2nd. Is that true?
Can we,
Yes.
can we do January 3rd, Judge?
Oh, January 3rd.
That's
Why
a
would that be the 3rd?
Tuesday. The January 3rd is a Tuesday, I believe, and that's a working day.
Monday the 2nd. I want him to turn himself in at 9:00 a.m. on Monday the 2nd to the Bear County Jail. Anything further from the state of the defense of Mr. Navarro?
Not from the state.
Nothing further on.
Good luck, Mr. Navarro. Thank you, Mr. Acevedo. Y'all are dismissed. And Ms. Kramer, are we ready on Mr. Trevino?
Yes, Judge. And before we go through that whole long thing that you just went through with Mr. Acevedo, Mr. Trevino has a pending remand without bond motion to revoke in the 187th with Phyllis Beal as his lawyer, and he has a new number 1 in the 187th. It's not fully my understanding, but it's the belief that this case will get swallowed up when the felony MTR is taken care of. So I was wanting to just go ahead and request my 10 days for a hearing, and then by that time, I'm sure Judge Boyd will have had the motion to revoke in her court. And in this case, we'll get swallowed up with that one.
I guess that's what we need to do.
Okay, that sounds good, Judge.
See, you were appointed what, whopping yesterday or something?
I believe yesterday. Yeah.
All right, reset this in County Court 6 for like, I don't know, 10 or 11 days, whatever works for Suzanne.
Okay.
And then Suzanne, you can take it up with the new judge on what she wants to do. And this may go away, or she may want to hear it. I don't know.
Yeah, I think it's going to go away. Thank you, Judge.
All right. Good luck, Mr. Trevino. Thank you, Ms. Kramer.
Bye-bye.
Yes, sir. Thank you very much.
And David, I don't have any, my file is at work or in a box somewhere. Would you please tell us the style and the case number of your case, and then I'll explain to Mr. Alvarado, because he's the new guy, the history I have on this case, which has been several months. And I think Johnson Heinrich was supposed to be researching this from the DA standpoint. And of course, now he's been moved to another court. But the facts, all we need, this is a motion to dismiss for lack of speedy trial. And my understanding, correct me if I'm wrong, Mr. Alvarado and Mr. Wheeler, is that federal law provides that if a state or federal government does not timely prosecute someone that they have charged with a crime, then he is eligible to have his case dismissed by the court based on the length of his delay, the reason for his delay, the assertion of rights from the defense, and the harm done to the defendant as a result of the delay. Do you agree with all that, Mr. Wheeler?
Yes, Judge, basically.
And
Yes.
Mr. Alvarado, is that also your understanding of the law?
Yes, Judge.
All right. So, Mr. Wheeler, give me the case number and your defendant's name, please, for the record.
Okay. I thought I had the case number here.
Your Honor, may I?
I've got it on your email, or if anybody has it, please.
I have it, Your Honor. May I?
Absolutely.
Cause number is 598916.
Name of the defendant.
Hong Ho Tai Don.
Doan. Yes,
Somebody
DOAN.
spell the name of the defendant.
Okay, it is HONG-HOA, then THI, last name DOAN.
Okay, I've got Mr. Wheeler's email from this morning, and
And Judge, he goes by Lynn, if that's easier. kind of like Angie.
this is cause number 598916, styled State versus Doan, spelled Delta Oscar Alpha November DOAN, Hong Hotel Oscar November Golf HONG, HOA HOA Hotel Oscar Alpha THI Tango Hotel India. But we're going to use, for purposes of the record, Lynn from this point forward. Would that be accurate, Mr. Wheeler?
Yes, Judge.
Okie doke. And once again, this is a motion to dismiss for lack of speedy trial. What the court needs to know and the state needs to know, what is the original date of the offense alleged?
The offense date is July 7th, 2018.
And what is the date of the information being filed? Do we know that?
Hold on, Your Honor.
I can give you the exact date. Hold
Yeah.
on. I have that it was sent, the complaint was filed October 23rd, 2018, Your Honor.
That should be the same date as the information, but not necessarily.
It says complaint, and then it goes into a court, and then I've got a file was sent to County Court 6 on that date, October 23rd, 2018, and there would not have been a file sent to us, Your Honor, if we did not have the information filed.
Mr. Wheeler, do you know of your own personal knowledge whether or not an actual information formally was filed in this case?
I believe it was, Judge. I
So-
don't have a copy of it in front of me, but you issued a warrant on October 23rd, 2018 for her arrest.
All right, so I've got an offense date 7/7/18. We all agree?
Yes.
I've got information filed 10/23/18. We all agree?
I believe it was filed before that, Judge. It was received in your court on that day.
Pat, you don't have any information on the specifics of when that, you have a complaint filed on 10/23/18?
Yes, Your Honor, and it went to Criminal Central Filing, which
All right.
means that that's when it was sent.
Let's just say on or about 10/23/18 for our purposes. That's going to be okay. And the
Okay.
date that the defendant was actually arrested was when, Mr. Wheeler?
March 14th, that's 3/14 of 2021.
Plus or minus 3 years after the offense date. Would that be accurate?
33 months, over 33 months, yes.
Okay, I got you. Okay, so the Barker v. Wingo test, 4-prong test, one is length of delay. Presumptively, 8 months is a trigger date period to allow a defendant to request that his case be dismissed for lack of speedy trial. Obviously, we have met that burden times 3 or 4, I guess. Information was filed timely, arrest 3 years later, somewhat unusual, but not completely so, other than during this 33 months that the defendant had to wait to start to defend her case. And of course, now it is 12/30/22. So how many months has it been or years has it been since 7/7/18 till today?
4 and some change. 4
years?
5 months.
4 years, 5 months?
Yeah, 4 years and
All right.
5 months.
But I think we can all agree that all the time issues have been satisfied by the defense. Do you agree, State?
It's been a long time, Judge.
All right. We all agree that the time is check. Let's talk. And obviously the assertion by the defense, I think you did it, what, several months ago? I'm guessing, Mr. Wheeler, I don't have the date in front of me that you filed your motion.
It was filed November 3rd, 2022, Judge.
Thank you.
With the affidavit of Alicia Fisher attached to it.
All right. So my position would be that the defense has complied with all the time period issues above and beyond the call of duty. Let's talk about the one remaining issue, and that is harm or prejudice done to the defendant as a result of the delay. What do you have to say about that, Mr. Wheeler? Has your client suffered any harm or prejudice because of this time delay?
Well, she suffered all of the problems associated with having to pay for a bond, having to hire a lawyer, having extreme anxiety as a result of this. She reflects in her affidavit, and so does Ms. Fisher, that her business was bombarded by the alleged victim and her family and friends with Facebook complaints and reviews and threats, and that she was very upset by this, and it's affected her business. And also her arrest has kept her from getting a small business administration loan because of the pending assault charge. Her business has been affected. She's been affected. Her sleep and general health have been affected. Alicia Fisher is married to an Air Force Master Sergeant. In January of 2021, about 3 months before Lynn was arrested, her husband PCS to Utah, and she moved up there. She has a master's degree in criminal justice. She worked here for the Texas Department of what's it called? Family and here, I'll tell you exactly. When she was here, she's now a victim's advocate for this sheriff's office in Davis County, Utah. And she was previously an investigator and caseworker for the Family and Protective Services. She was a Family and Protective Services investigator and caseworker for the Texas Department of Family and Protective Services.
And let me interrupt you there. And this was going to be a witness that was present at the scene of the incident and was going to testify on behalf of your client. Would that be accurate?
Yes, Judge. Now, this witness, when we originally received the police reports, we did not originally receive the videos. We got them a little bit later. So we got the police reports, and in the police report, it says that Alicia Fisher didn't see anything that happened outside, which is where the alleged assault occurred. But when we finally got the body cams, then we saw Miss Fisher being interviewed by the officer that was at the scene. There were two officers at the scene. One officer, a young Hispanic male, was talking to the alleged victim, a young Hispanic female. He seemed very, I don't know what the right word is, fascinated by her. He was smiling and laughing and with her, and he's the one that wrote the report that said that Alicia Fisher didn't see anything. The other officer who interviewed Miss Fisher, which when we saw the body camera footage, that's when we knew that Alicia was a witness. Alicia told him, I was sitting next to this woman in the shop. I saw the way that she was treating the technician that was doing her nails and also the owner. My service, she got up and was using a lot of profanity. She walked out without paying. I was finished with my services. The little girl with her, the two of them got up and walked to the front of the store. And she said, now watch what happened. And the officer said, well, she says that that Lynn pulled her out of the truck. She said, no, I didn't see that happen. I saw Lynn go out and walk up and speak to her, asking her to pay her bill. And the woman was refusing, and she was waving money at her and taunting her and things like that. But she clearly saw what occurred, and the officer's report was inaccurate, which threw us off at first. Then we discovered that Ms. Fisher was a witness when we saw the body cam footage. We contacted her, and she provided the affidavit that was filed with the court on November 3rd, 2022, almost 60 days ago.
And Ms. Fisher is now physically located in Utah, did you say?
Yes, Judge. She is no longer amenable to subpoena or available to testify in this case.
Okay. State, what do you want to do?
Well, Judge, first, let me note that I believe the last time that we were set for trial, which was in November, there was a motion for continuance. I'm trying to go back to this here. Or perhaps maybe it was before that, one of the previous times we were set for trial. There was a motion for continuance that was filed and ultimately granted, and it was the defense motion. So, Your Honor, I think this goes to negate the argument that there's been harm caused by the delay in speedy trial if the defense is filing their own motion for continuance when it comes to this case.
I don't, obviously we have hundreds of cases going by, but my recollection is that because they didn't have this witness, they weren't really ready to go to trial, and that's why they wanted a continuance. Now, Mr. Wheeler, do you have any recollection of that?
There are other witnesses also, Judge. We don't know, because there was such an extremely long delay. We don't know what other Customers were at the shop that day. Some of the employees no longer work there that were present that day. My client's ability to defend herself in this case has been harmed at many levels, and she has suffered prejudice as a result of the delay.
Is this an SAPD case or Bear County Sheriff's case?
Surprisingly, it's SAPD.
Okay. And apparently, has Lynn had this shop there ever since the initial incident and never moved or never gone anywhere?
That's correct, Judge. And her residence address remained the same until she was arrested at home under warrant. She wasn't picked up at like on a traffic violation. They actually went to her home and arrested her on March 14, 2021.
But the police did not arrest her on the date of the original incident, July 7, 2018. Is that correct?
That's correct, Judge.
And do you have any understanding of why that was?
I think they left it to further investigation at that point.
Okay. But I find that somewhat unusual. Anytime there's a crime and somebody says that person did it, they arrest them and that's it. Well,
The only person with visible injuries that day was Lynn, because she'd been kicked in the face and her lip was bleeding. Likewise, the person that was attempting to leave without paying for services was the alleged victim. So beyond that, I cannot explain why it occurred in the way that it occurred. But then it took them, as I said, over 33 months to get around to arresting her.
State, I think in the interest of justice, in my mere 44 years as an attorney, I don't think I've ever seen a case that took this long for law enforcement to arrest the defendant. DA's office did nothing wrong in this. They accepted the charges, they filed the information, and they put it back on as a warrant for arrest. And then the police just drug their feet apparently and going tracking this lady down. I don't know why that would be. Do you know anything I don't know? And obviously you probably don't, because I just sprung this on you today.
Right, Judge. I mean, without looking further, I know my previous place of employment, there was ways you could look at attempts to serve warrants. You could look and see, had there been attempts to serve warrants previously. I'm looking at my system. I don't see anything like that just off on its face. I do agree with the court. It is a long time for somebody to be picked up on a case like this. I would just argue, Judge, that the state has been ready in this case in the previous trial settings. And although it has been a long time, the defendant is out on bond while this is going on. And the harm and the prejudice that counsel is describing is unfortunately the harm and the prejudice that happens when somebody is charged with a criminal offense. I don't think it's necessarily unique to this particular circumstances. So, Judge, I would not obviously agree to this. I would object to any granting of the defendant's motion.
I believe another reason for my continuing this case back in November was Mr. Sanheinrich was going to do some further investigation, and I never heard back from him on it. Mr. Wheeler, do you ever have any further contact with Mr. Sanheinrich?
I conferred with him as you instructed, Judge, but then I never heard back from him either.
All right.
Well, and Judge, obviously I wasn't there, so I don't know for sure. The notes from the case that I'm seeing are from Mary, the ADA McAuliffe. I think this is actually technically her case because it ends in an even number. That's the way that it's been explained to me, at least. And so I from what I'm reading here, she was ready to go to trial on that previous setting.
Well, if I was the prosecutor, I'd be ready too if the defense primary witness was in Utah.
Well, and Judge, you mentioned that. Correct me if I'm wrong, counsel, but I believe you said that information was provided to you more recently in the past month or two.
No, I said when we got the videotapes, the body cams, excuse me, that's when we realized that she was an important witness. And then we tracked her down eventually and talked to her And the day that I received an affidavit from her, I filed the motion with the court.
And what date was that?
November 3rd, almost 2 months ago.
All right. Well, the prosecution's objection is noted for the record, and for appellate purposes, I'm going to grant the motion. I just find this incredible amount of time of 4 years, 5 months, plus or minus, from the date of the offense to the present day when we're hearing this, is totally egregious and accountable to the San Antonio Police Department, and not at all to the Bexar County Criminal District Attorney's Office. Anything further from the state of the defense on this case?
No, Your Honor.
Okay, Judge.
All right. I think we're done with you, Jonathan. I don't think we have anything else to bother you with. You're going to have to go train a